Hi guys, this is Asal. I'm studying for the bar and I wanted to review my notes with you. So today I'm studying civil procedure and I'm studying FRCP 12, Federal Rules of Civil Procedure 12. So actually this rule is very important because civil procedure is actually like a game of chess. So what happens, one party will bring a claim and then the other party has to respond. So what I want to talk about first is failure to state a claim, because a plaintiff will not prevail even if all the factual allegations are true. So how does this work? Someone will bring a claim and then the other party will respond with, so what? This isn't good enough. So that's how failure to state a claim works. What I want to talk about next is the Rule 8. Rule 8 says that a pleading that states a claim for relief must contain a short and plain statement of claim showing that the pleader is entitled to relief. So what does this mean? This means that there must be a short and plain statement to show that the plaintiff is entitled to relief. That's all there is to it. The next rule I would like to talk about says that a complaint should not be dismissed for failure to state a claim unless it appears beyond doubt that the plaintiff can prove that no set of facts in support of his claim which would entitle him to relief. So if there's no set of facts, then he's not entitled to relief. So the next thing I would like to talk about is, how does the court operate? So in deciding a motion, the court considers these three things. The first one is the face of the complaint. That's very important. The second one is all the documents attached to it. And finally, the judicial notice. So remember that. The next thing, I would like to talk about the allegations that are taken as true. So there's the real factual allegations that basically state circumstance, events, and actions. These must be accepted as true. And then there's also the legal conclusions. These legal conclusions, they're not accepted as true. You cannot do that. You cannot recite the elements and then say, yeah, this happened. No, they're not accepted as true. And then the next thing I would like to talk about is plausibility. So here, does the complaint assert a real fact? It's very important, because if not, the complaint must be dismissed. But if yes, does the fact state a facially plausible claim? Is there a facially plausible claim? If yes, the complaint must be sustained. If no, complaint must be dismissed. So remember that. And then the next thing, the 12B6 motion. This defense can be raised by pre-answer motions, in the answer, or by the motion for judgment on the pleading. So now the next thing I would like to talk about is this rule, because this book is very important. This rule is very important. This is what it looks like. My professor had me highlighted in class. I took this class in 2018, so I'm probably gonna have to buy a new book when I graduate. But let me jump right into it. So the part I was talking about was the part B, the 12B6, right? The 12B6. So it says how to present a defense. That's very important, because every defense to a claim for relief in a pleading must be asserted in the responsive pleading if one is required. So there are these 7 parts. The first one is lack of subject matter jurisdiction. The second one is lack of personal jurisdiction. The third one is improper venue. The fourth one, insufficient process. The fifth one, insufficient service of process. Sixth, failure to state a claim upon which relief can be granted. And 7, failure to join a party under Rule 19. So what I'd like to do next is actually repeat this rule again, because this is something that you have to memorize for the bar. I have to memorize it, and I'm going to memorize with you. So, lack of subject matter jurisdiction, lack of personal jurisdiction, improper venue, insufficient process, insufficient service of process, failure to state a claim upon which relief can be granted, and failure to join party under the Rule 19. So that's very important. And I would actually like to close out the video with that rule so that it sticks with you. I would like to talk about the first part of the rule that says that in general, unless another time is specified by the rule, the time for serving a responsive pleading is within 21 days. So that 21 days is very important. Remember that. And that's pretty much everything I wanted to say. So to summarize, I just talked about the plain and short statement. and also mere legal conclusions are not enough. Facts must make the plaintiff claim plausible. And finally, I talked about failure to state a claim. I truly hope you enjoy studying. Good luck.